Okay, let's talk Koberger status hearing. Today was the first time we were able to see Judge Hippler presiding over one of the hearings in this case, and he came out of the chambers in a rather spicy mood.
Like to tell you I'm happy to be here, but why start with an untruth? I am accepting of my responsibility to be here.
Wow, okay. I can't believe he said that, but at the same time, I kind of like that he did. And then he goes over some of his guidelines, including that the prosecution and defense need to get along.
Expectations of mine, given that I don't think any of you, other than Ms. Massoth, have appeared in front of me before. Um, When you file memorandums of law, briefs, etc., please provide a Word copy by email to my staff attorney. After today's hearing, you may get that from staff here today. It probably will come to no surprise to you for you all to get along. I understand the stakes in this case are as high as they can possibly be in any case, but you are professionals. You have taken oaths, both as of officers within your jurisdictions, but also as attorneys before this bar. So I expect at all times for you to remain civil to one another, that you not engage in personal attacks, ad hominem attacks, that you not engage in theatrics, not misstate the facts or the law to the court, and that when you cite arguments in your briefs, if there is contradictory precedent, I expect to see that. I appreciate in advance what should go without saying that I've just said in terms of your responsibilities. But again, I just want to highlight that because I understand when the stakes are high, sometimes victory seems to be the objective when our first objective is to conform to the oaths that we've taken as members of the bar, as officers of this court.
He then went on to talk about how he had issued an order that it was okay for Koberger to be in street clothes for today's hearing, but he hadn't decided yet for the rest of the hearings. So there would be a hearing about that later with an order to come before the next hearing. And then after he discussed that, he went into talking about the non dissemination order.
Judge had entered a non-dissemination order. That still remains in place. And unless I, for some reason, remove that order, it will stay in place, and I expect it to be religiously adhered to by all parties, counsel, victims, counsel for the victims, and I will not tolerate violations of that. Likewise, I know that much of the evidence in this case has been subject to orders sealing under that dissemination order or otherwise have been sealed by the court. I likewise expect everyone that has access to that information, whether it's sealed documents or information in sealed hearings or the information itself in the documents, to adhere to the confidentiality expected as it relates to those. That's my one and only lecture for you for the remainder of this case.
So after that, then he asked the attorneys if there was any concerns they wanted to bring up, and Bill Thompson really had nothing. He just pointed out that they would like to know the scheduling order, especially with them coming from Latah County for hearings. But Ann Taylor had a whole host of things that she wanted to bring up. Not surprised, really.
Thank you, Your Honor. There are a few issues that I wanted to make the court aware of as the court decides on the scheduling order. We want the court to know that our team has been working towards the June of 2025 trial date that had been issued by Judge in the case. But in candor to the court, I need to let the court know some issues that have come up that we face that causes me concern. First, I think the court's probably aware of the vast amount of discovery that's been exchanged in the case by reviewing the record. But since August, we have received about 398 gigabytes of new information, and I can tell the court that nobody on the team has read every bit of that yet. So there's a vast amount of discovery to continue to go through, and I wanted the court to be aware of that. The second thing is that during the course of this case, we had an expert that we were working with, and that expert passed away. We have been able to refill that role, to have a new expert to do the work that that expert was hired to do, but we are not progressed to the point that I'd hope to be through no fault of the new expert. The court should be aware of that as well. And last, as the court is very well aware, the system of delivering public defense is changing next week. As appointed counsel in the case, I do not have a contract yet. Nobody on my team is under contract for this case. I'm concerned about what that means, and I thought the court should be aware. Further, we have been able to access funding to help us prepare this case through Idaho Criminal Rule 12.2. At the current time, we're working with about 25 experts and investigators to prepare the case. I don't know if 12.2 will continue to be the way to get funding for those experts and investigators, or if that's changing. And I thought the court should know those things. Thank you.
So that was interesting. We now know she has 25 people on her team, which kind of makes me wonder why she always acts like they need more time, but that's a discussion for another place. So the judge did address that he had asked the judge that's involved with the budgeting to stay on through at least the transition to the new system, where public defenders are not based out of the county, but they're actually state employees now. And then he said that, obviously they will be taking a look at those changes to the state codes based on that to see how it will affect this trial going forward. And then he asked both of them what they thought they would need time-wise for a trial to present their cases.
I'm concerned with a trial as currently set for a number of reasons, but first I want to find out from you, as you sit here today, what that trial looks like in terms of the number of weeks of trial, starting from after a jury is selected through the end of the evidence and before any potential sentencing phase. So what are your estimates of that?
Your Honor, I think it would be a fair estimate based on what we know at this point to have a month and a half or perhaps a bit more just for the evidence for the guilt phase of the trial. I say that knowing...
Is that just your evidence, or does that include defense evidence?
Well, I was just getting ready to say, I say that understanding or acknowledging that Ms. Taylor has estimated 2 to 3 months total. I do not know. We do not know what the defense has in mind for their case right now, so all I can speak to is what we anticipate for ourselves. But I would think the state's evidence in chief should be able to come in a month and a half or so.
Okay. Ms. Taylor?
Your Honor, we estimate 4 weeks for the defense portion of the trial case.
Of the guilt phase?
Yes, Your Honor.
10 weeks. In terms of if there is a penalty phase, should the defendant be convicted of one of the statutory qualifying offenses, how long do we estimate the penalty phase being?
Your Honor, from the state's perspective, I believe we're going to be relying heavily on the evidence that's introduced during the guilt phase and the additional evidence that would be brought in, unless there's something we learned from the defense about their experts, it is probably would take no more than a week.
Taylor?
Your Honor, I would estimate 2 weeks for that part of any trial.
That's
For our evidence.
For your evidence.
Yes.
So at that point, then the judge said that he had concerns about the trial running through the summer and proposed that they either would start it in May or in September. Let's take a listen.
So my concern, because this trial is currently set to begin June 2nd and end approximately August 31st, is having it set to run the entire course of the summer, I think we will find to be difficult on jurors in particular. Jurors who may have children who are out of school. I had two proposals. One was to start the trial in the evidence portion of the trial the first week of May. And the other would be to start the evidence in early September.
So he was talking about parents wanting to go on vacation with their kids, and then he also brought up children going back to school in August, and of course parents wanting to be there to bring their children back to school. And then he asked the prosecution and the defense if they had a choice between May and September, what they would choose, and I think you pretty much know what both of them were going to choose. It was not a surprise to me.
And I'd like your thoughts on those. I'm not saying I'm have or necessarily will vacate the June trial date, but I want to look at alternatives here because I am concerned about that spread that takes the entirety of the summer.
And we hear you, Your Honor. By way of history, the summer, we advocated for that in Latah County because the courthouse is right across from the high school and the summer would have the students gone. If we were looking at the other two choices, we would propose May.
Taylor?
Thank you, Your Honor. Your Honor, I would have to advocate for September at this point, based on the three reasons that I gave the court before.
So then the judge addresses Anne on that. And I thought it was interesting because a lot of times Judge wouldn't really question Anne when she was asking for more time. And he would just usually go ahead and extend deadlines for her. And this judge said right away, May is a long ways off. But then he also asked her about needing more time because of the expert that passed away. And she suggested that they meet ex parte to discuss it.
The one thing that you brought up the most, I mean, I understand there's a lot of evidence, but May is not tomorrow. May is many months away. So the one that concerns me that you brought up is your expert. I'm not asking you necessarily to give away any secrets prematurely that you may have in terms of defense strategy, but can you help me understand this expert, if you're able to, and what their role is and what the prospects are?
Your Honor, it's really difficult to tell you much about the expert without giving away a lot. I can tell you that this is a very necessary expert for us to have on board. We've been able to find somebody to fill the role. I'm confident in the person that will fill the role. There just hasn't been enough time to get the work accomplished yet. I know that that doesn't tell the court a whole lot more than what I said before, but I really feel that that would disclose too much for me to say more. I could do so on an ex parte basis or with Judge Monson, our resource judge, but not in a public setting.
I understand.
He then went on to ask her if she thought she could meet her deadline in January for turning over the witness information to the prosecution.
Do you anticipate being able to fulfill your obligations for your current expert disclosure deadline that was set by Judge?
No, not with a lot of confidence. I think that the work is going to take longer than to meet that deadline. I think if we met that deadline, I would have additional information that I would want to be able to present, and maybe I would have been stopped from that with that deadline.
So then he went on to point out that he hadn't received any motions from her yet to extend out that deadline. And then he asked the state what their thoughts were on it.
Does the state have anything to say in response?
Not knowing the details of the challenges Ms. Taylor and her team are facing, I don't really know how to respond further, Your Honor.
So yeah, Bill basically deferred to the judge, and then the judge goes on and asks Anne if she feels that she can make the deadlines. And we also find out that it was the mitigation expert that passed away.
What do you think is a realistic deadline for you to be able to disclose your experts for everything? I'm assuming it was January, all save that one expert. But with respect to the expert you had to replace, when do you think you could disclose consistent with the scheduling order?
Other than the expert that had to be replaced, Your Honor, there were two separate deadlines. One was for trial experts and one was for mitigation experts. And I believe that I can make that deadline other than that one expert,
Can you tell me if the one expert is a mitigation or a trial expert?
a mitigation expert, Your Honor.
And what do you think you need for that mitigation expert in terms of a deadline? That mitigation deadline was,
I believe it was March. I don't recall the exact date.
yeah, so that's a long time from now. So, I have a lot of questions, but I'm hesitant to ask you the questions because I'm sure you're not in a position to answer them currently, given the forum.
So then Anne went on to say that for the mitigation expert, if she had an end of April deadline, that would work. But the state wasn't too keen on that if a trial was going to start in May.
So, understanding this is a mitigation expert, Thompson, how concerned are you about getting that disclosure closer to trial?
Closer to trial is somewhat relative. The end of April sounds like it would be on the eve of trial from the date the court is proposing. I think that would be, I'm not sure that would be realistic. And again, I'm not in a position to second guess
Sure.
what Ms. Taylor and her team are representing to the court. She had told us some time back that one of her experts had some health issues, and I think that she did tell us that that person had passed away and they were working on a replacement. If we're looking at a mitigation disclosure at the end of April, I don't know that we could be ready with all the final trial preparation for a May trial. I hate to say that, I feel like I'm cutting my own throat in a sense, but that's realistic.
So then the judge went on to say, he has one of two options. He can either set a deadline for that expert witness information to be turned in, or he could set a trial date of September. Or they could hold an ex parte hearing about it. But I thought it was interesting because he said if he sets a deadline, he knows it would be met because there's so many hours in a day. Like, basically, he does not seem to be putting up with any of this, oh, I don't have enough time to review things, excuses. So I'll play you that little clip there.
I can set a date, and my experience tells me that date will be complied with regardless, right? 24 hours in a day, but if you use enough of those hours, enough days in a row, you get it done if you have to.
So then the judge asked Bill Thompson what he thought, and Bill said he would trust whatever the court decided. So the judge decided that he would like to do the ex parte hearing with the defense. So Ann Taylor did agree to do that ex parte, and as far as we know, they met immediately after the hearing, the defense and the judge, to talk about what time frame might be needed due to this mitigation expert passing away. And then the judge asked about if they had met the discovery deadline, which was earlier this month.
We have, Your Honor, and in fact, Ms. Jennings prepared a lengthy summary of all the discovery that was filed with the Latah County Court when our discovery deadline hit. It is lengthy, but there's a lot of discovery.
Sure.
We recognize
How
that
much of the, would you say 300 gigabytes?
$398 since August 13th.
How much of that is new information?
Ms. Jennings could speak to that.
Ms. Jennings, can you speak to that?
Your Honor, the defense was given, and I'm not sure if this is what they're referencing, but they were given a copy of the OneDrive from the FBI. Most of that was cumulative discovery that they had already received in another fashion. I'm sure there were portions of it that was new information. I've not calculated how much of that was new. So I can only rely on Ms. Taylor's, what she's represented to the court on that.
Well, I don't think she knows because it doesn't sound like she's looked at it yet.
Not all of it, Judge.
Okay. All right.
That was an interesting exchange because it looked like Ashley wasn't exactly prepared to answer that. But we did hear her mention a OneDrive file from the FBI. So hopefully that does contain that final draft report. And then the judge asked if either of them had anything else they wanted to discuss. Bill had just asked if they wanted him to stick around for the ex parte hearing, even though they wouldn't be in there with the defense. And the judge said, yes, might not be a bad idea for you to hang around because if I could make a decision, I could tell you now. And then he asked Anne if she had any other outstanding motions besides the death penalty challenges. She said no, but she would have more motions she'd file, and there possibly could be more discovery motions coming, but she hadn't looked through everything yet. And then the judge had this to say before the hearing ended.
Right. I think you will find I'm probably more inclined to hear things more quickly than you're perhaps accustomed to in this case.
So he told them to be aware of that, how he decides things more quickly. So my thoughts on Judge Hippler are I like him so far. I like Judge too. He was more laid back. But the problem I had with Judge is he would let Anne use excuses a lot and push out deadlines for her. The alibi, for example, when the first deadline came and went, he went and set a new one for her when there should have never been a new one set. The IGG technically didn't need to be turned over, but he went ahead and kept dragging it out and letting her put in more motions about it, then finally decided, yeah, she could have some of it. And then he just, like I say, every time she had an excuse for a deadline, he'd roll his eyes, but then he would buckle. And this judge doesn't appear like he's going to buckle. He mentioned more than once that March is a long way off. That's a lot of months away. And then about January, that he felt like she could make a January deadline if needed. And then how there's 24 hours in a day and you can get it done if you need to get it done. So I think he's no nonsense. He's going to set deadlines. He's not going to put up with bullshit. And that's going to be interesting to see how the defense deals with a judge like this.